As is the practice of this committee, first of all, I welcome you here, and second, I have the duty to administer the oath so that you can be sworn. If you would please stand and raise your right hand. Do you affirm that the testimony that you are about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. I'm going to give very abbreviated introductions in the interest of time because we're running a bit late, but I'll ask that the full summary of your resume be submitted for the record. First of all, Laura Donohue is a professor of law at Georgetown Law School and the director of Georgetown's Center on National Security and the Law. She writes on national security and counterterrorist law in the United States and the United Kingdom, and I understand that your most recent book is entitled The Cost of Counterterrorism, Power, Politics, and Liberty, and that you're currently at work also on an article or a book on the NSA's metadata collection program, as well as drones, and the War on Powers resolution. Professor Felten is a professor of computer science and public affairs at Princeton University and the founding director of Princeton Center for Information Technology Policy. I understand that you were the first chief technologist at the United States Federal Trade Commission, and that you're a member of various scientific bodies, and that your research includes interest in computer security and privacy, especially relating to consumer products and media, technology, law, and policy. And finally, Carrie Cordero, who is the Director of National Security Studies and an adjunct professor of law at Georgetown University Law Center. I understand that you have written and studied in the areas of also national security and counterterrorism, as well as counterintelligence investigations. You've had a number of very significant positions in the Department of Justice and helped to formulate American policy in these areas before your service now in the private sector. I won't go into all of the positions, but they are extremely impressive. So maybe we can begin with you, Professor Donohue. You'll have to turn your microphone on.
Got it. Thank you. Thank you for inviting me here today to discuss really much needed reforms to FISA, with particular reference to sections 215 and 702. I've submitted very detailed written remarks for the record. So for now, what I'd like to do is just highlight what I see as the most pressing concerns. Specifically, it is my view that the bulk collection of U.S. citizens' metadata is both illegal and unconstitutional. The government argues that the metadata program complies with the Constitution. In so doing, it relies in part on the case that you mentioned that held that individuals lack a reasonable expectation of privacy in the numbers that they dial. The government also suggests that the national security interests at stake override whatever privacy intrusions might result. For two reasons, these arguments are problematic. First, the metadata program amounts to a general warrant, the use of which by the English played a key role in the American Revolution and led directly to the Fourth Amendment. A general warrant was a writ. It was issued by a court, it did not expire, and it allowed officials to collect information to search anywhere without any particularized suspicion. In 1760, the British Prime Minister, William Pitt, directed colonial governors to use these writs of assistance to crack down on illegal behavior. James Otis famously challenged them as the worst instrument of arbitrary power. And John Adams later wrote that this oration breathed life into this nation. Then and there, John Adams reported, was the first scene of the first act of opposition to the arbitrary claims of Great Britain. Then and there, the child independence was born. The Virginia Declaration of Rights subsequently included a clause outlawing general warrants. Similar language was adopted by Massachusetts and New Hampshire in their state constitutions, and later the ratifying conventions, the most important ones, New York, Virginia, and North Carolina. They required that a prohibition on general warrants be incorporated into the Bill of Rights. James Madison wrote the Fourth Amendment to prevent the use of general warrants. They were the definition of unreasonable search and seizure. The Fisk Order authorizing the telephony metadata program is a general warrant. It authorizes the government to collect and then to rummage through our papers and effects in the hope of finding wrongdoing. There is no prior suspicion of criminal activity, and almost none of the information obtained actually relates to illegal behavior. Second point, in defending the program, the government relies on the 1979 case called Smith versus Maryland. In that case, Patricia McDonough was robbed in Baltimore. After giving the police a description of the man who robbed her and the 1975 Monte Carlo car that he drove, she started receiving threatening and obscene phone calls in her own home from a man who said he had robbed her. Then he phoned her and had her come out on her front porch while he drove slowly by the house in the Monte Carlo. The police saw the car in the neighborhood, got the license plate number, and identified that the car was registered to Michael Lee Smith. The police asked the telephone company if it would put a pen register on Smith. That day, he called Patricia McDonough's home. On the basis of this and other information, the police obtained a search warrant. They went into the house and they found a phone book turned down to Patricia McDonough's name. Michael Lee Smith had robbed, threatened, intimidated, and harassed Patricia McDonough. The police placed the pen register consistent with reasonable suspicion of criminal wrongdoing. The NSA would treat every American as though they were Michael Lee Smith. And it would collect not just the numbers dialed from the home of a suspected criminal, but all law-abiding citizens' metadata: whom we call, who calls us, how long we talk, calls to a rape crisis line, a suicide hotline, or political party headquarters reveal much more than what was sought in Smith. The government's argument could be extended to any sort of metadata: email, banking records, financial transactions, and internet use. The extent to which we rely on electronic communications to conduct our lives is fundamentally different in scale and scope than what happened in 1979, and the NSA would do this indefinitely. Americans reasonably expect that their movements, communications, and decisions will not be recorded and analyzed by the government. A majority of the Supreme Court seems to agree. In 2012, the court considered a case involving 28-day surveillance using GPS chips. This case recognized that Katz's reasonable expectation of privacy test does not supplant the rights that existed when the Fourth Amendment was written. At a minimum, Justice Scalia wrote, the 18th century guarantee against unreasonable searches must provide the degree of protection it afforded when it was adopted. The protection against the general use of warrants thus stands. In addition, at least 5 of the justices indicated unease with the intrusiveness of modern technology. Justice Alito, joined by Justices Ginsburg, Breyer, and Kagan, suggested that in most criminal investigations, long-term monitoring impinges on expectations of privacy. Justice Sotomayor went one step further. She suggested that disclosing information to a member of the public for a limited purpose does not divest that data of Fourth Amendment protections. The telephony metadata program also violates the express statutory language of the Foreign Intelligence Surveillance Act in at least 3 ways. First, the government argues that the NSA's telephony metadata program is consistent with the statute in that all telephone calls in the United States, including those of a wholly local nature, are relevant to foreign intelligence investigations. The use of the word relevant here is so absurd as to render the term and the qualifying statutory language meaningless. Second, tangible goods subject to the order must be obtainable by subpoena ducis tecum, but no grand jury or court would allow the bulk collection of all Americans' metadata. It is illegal to use subpoenas for fishing expeditions. Subpoenas, moreover, are specific. They relate to a particular individual or crime, and they deal with current or past bad behavior. The metadata program, in contrast, is broad, non-specific, forward-looking, not tied to a crime, and looks to anticipate future acts. Fisk itself has recognized the illegality of the program. In March 2009, Judge Reggie Walton acknowledged that metadata could not otherwise be captured in bulk. Third and finally, as a statutory matter, all of the information at issue in the bulk collection program is already provided for in FISA Subchapter 3, dealing with pen registers and trap and trace. Using Subchapter 4, the government appears to be doing an end run around the restrictions that Congress placed on the NSA. The system, in my view, is badly broken. The NSA is engaging in activities that are illegal and unconstitutional, and Congress has an opportunity to fix the problem, and to do so in a way that recognizes the benefits of new technologies, the real threats the nation faces, and the demands of the U.S. Constitution. Thank you.
Thank you, Professor Donohue, and I might just say that all of your full statements will be made a part of the record without objection. Professor Felten.
Mr. Chairman, Ranking Member Grassley, members of the committee, I thank you for the opportunity to testify about technical issues related to surveillance. I'm not an expert on the law, and I offer no opinion on the legal status of any program, nor do I presume to say how best to balance the legitimate goals of conducting foreign intelligence surveillance against the legitimate goals of protecting privacy and promoting civil liberties. I hope that my testimony will help you appreciate the power of metadata and control its use appropriately, consistent with the need for effective foreign intelligence. The NSA has acknowledged that it is collecting metadata, who called whom, when, and for how long, about nearly all phone calls in the US. Earlier, General Alexander said that the NSA is not currently collecting location data, but if it were to begin collecting location data, this would raise additional serious issues. With today's analytic tools, metadata often amounts to much more than just a list of numbers dialed. Often it reveals information that could traditionally be obtained only by examining the contents of communications. Metadata can now yield startling insights about individuals and groups, particularly when collected in large quantities across the population. It's no longer safe to assume that metadata is less revealing or less sensitive than the content it relates to. Just by using new technologies such as smartphones and social media, we leave rich and revealing trails of metadata as we move through daily life. Many of the details of our lives can be gleaned by examining those trails. And the only reliable way to avoid creating those trails would be to avoid using these technologies altogether. Metadata can be highly personal, a series of calls to an oncologist or an obstetrician, or to a suicide hotline, or to an alcoholism counselor, or to a competitor's personnel office, or to an inspector general. The pattern of calls reveals content. Metadata also reveals relationships. Frequent late-night calls can reveal an intimate relationship. Calls to a counselor or divorce lawyer can reveal the state of a marriage. Calls to parents or siblings, or a lack of calls, can reveal the status of family relationships. Metadata is naturally organized in a way that lends itself to analysis. By contrast, content is unstructured and can be difficult to analyze and understand. Today, a growing set of computing tools can turn metadata trails into penetrating insights, and given limited resources, analyzing metadata is often a far more powerful analytical strategy than investigating content, yielding more insight with the same amount of effort. When focused on intelligence targets, metadata collection can be a valuable tool. At the same time, unfocused collection of metadata across the whole American population gives government access to many of the same sensitive facts about the lives of ordinary Americans that have traditionally been protected by limits on content collection. Metadata might once have seemed much less informative than content, but this gap has narrowed dramatically and will continue to close. Today's hearing is a vital step in a process that should continue. Technical expertise is essential for effective oversight of these technologically complex programs, and I would respectfully urge you to consider how best to integrate technical expertise into the oversight process. As an example, the Foreign Intelligence Surveillance Court, in its declassified opinions, expressed frustration that the NSA had not disclosed significant technical information. The NSA's good faith effort to summarize the technology for the court's benefit could have led to the omission of information that the court later found highly relevant. Technologists within the NSA surely knew how their program operated, but this information had to pass through other people, some of them less attuned to the significance of certain technical details, before it could reach the court. And the court, without access to technical advice, was not able to ask the sort of probing technical question that might have elicited the missing information. The United States has the world's strongest pool of technology experts, many of whom are available to assist in the oversight process. I look forward to your questions today, and more broadly, to continued constructive engagement between oversight officials and technical experts. Thank you.
Thank you, Professor Felten. Professor Cordero, I want to apologize. I have to step out for a very quick visit with a group that's been waiting to meet with me. I've read your testimony. It's excellent. If I'm not back in time, Senator Grassley can proceed to questions, and I should be out for just a few minutes. So please proceed.
Okay. Thank you, Mr. Chairman. Ranking Member Grassley, members of the committee, thank you so much for the opportunity to be here today. In my written statement, I've provided the committee with information about my previous experience as a national security law practitioner, and that statement also recounts my experience working at the Department of Justice on September 11, 2001, and includes examples of how pre-9/11 law and interpretations of the law led to significant bureaucratic processes inconsistent with the speed and agility needed in national security activities. Indeed, in the years leading up to and then after 9/11, the FISA process was subject to the exact opposite criticism that it seems to be today. The Department of Justice was accused of being too reticent, too cautious, too unwilling to be aggressive under the law in order to protect national security. Subsequently, I had an upfront view regarding how the intelligence reform laws passed by Congress over the next several years vastly improved the intelligence community's ability to protect the nation from another attack on the scale of September 11th. So I'm here today to urge caution in implementing quick fixes that may sound appealing, but that could have lasting consequences at a practical level that could negatively impact intelligence community operations and the nation's security for years to come. I don't want to see us go backwards. Since the unauthorized leaks of this summer and subsequent reactions, I've observed three main critiques of the current FISA activities. Let me take each one along with some of the proposed reforms. First, with respect to the proposals to restrict collection under FISA, my perspective, these arguments that these programs, and I'm referring to both the 702 and the 215 program, are illegal, are mostly arguments about what the law should be, not what the law is. That said, the government's interpretation of 215 is a more forward-leaning interpretation of the law than is its implementation of 702. 702 collection is targeted against non-U.S. persons reasonably believed to be outside the United States. These are not individuals with constitutional protections, and the collection against them is conducted in accordance with the statutory framework debated extensively and passed by Congress in the FISA Amendments Act of 2008. The metadata collection under 215 is obviously large in scale, but I would submit that the government's arguments in this case are consistent with existing precedent, no matter what direction the courts may go in the future. I would commend to the committee the recently declassified opinion and order by Vice Judge Claire Egan dated August 29th, which offers a straightforward analysis of the law that explains why the court continues to approve this collection. In addition, senior leaders of the intelligence community continue to advise that the 215 program remains a valuable part of the protective infrastructure that was implemented after September 11th. Therefore, in my view, it would be premature for Congress to abruptly end the 215 program through legislation. Second, with respect to the proposals to enhance public confidence, two themes emerge in proposals to add a special advocate or public interest advocate to the FISA process. One view is that the court could benefit from an additional view, particularly in cases involving technical complexity or novel legal issues. A second view is that the special advocate would go a long way in restoring public confidence. I have concerns about both proposals. If what the court seeks, and it would be helpful to hear from the current court on this issue, is simply an additional view beyond that which is presented by the Justice Department on behalf of the intelligence community, then I would submit that empowering the existing Civil Liberties Protection Officer, a position created by Congress, to present his views directly to the FISC would serve that purpose. This proposal would address the substantive concern that the court could benefit from an additional view, and it would do so without adding substantial layers of additional bureaucracy. On the public confidence point, I would suggest that an outside advocate would not carry the weight that it is hoped it might provide with the public in the longer term. If done in a manner protective of classified information, the advocate would necessarily work in secret alongside the executive branch. With the passage of time, outside observers will just see the advocate as another participant in a secret process. So what would enhance public confidence? Perhaps the most frustrating part of the reaction to the leaks from my perspective has been the nearly complete lack of confidence in or comfort by the existing oversight mechanisms, particularly with respect to 702 collection. I can personally attest that the oversight is extensive and exhaustive. So I'll offer a few suggestions of what might be steps in the right direction to bolster both congressional and public confidence. One, Congress can ensure that the offices conducting oversight are staffed and funded appropriately to their responsibilities. The internal executive branch oversight process that has been built requires a lot of man-hours to do it right, and the quality of oversight will suffer if any of these offices are stretched beyond their capabilities. No doubt there's an irony here in making this point in the midst of government shutdown. Two, Congress could consider requiring an annual or semi-annual public report that produces information currently contained in the classified Joint Compliance Assessment. This report might better help inform members of Congress beyond the Judiciary and Intelligence Committees regarding the oversight and compliance process. 3, Congress should focus its efforts in working with the NSA, the Justice Department, and other components in the intelligence community to reduce the complexity of internal procedures. I've explained the reasons for this recommendation in greater detail in my written statement, but to summarize, one aspect of reducing compliance incidents is reducing the complexity of internal operating procedures to ensure that operators at the working level understand the rules they're operating under. Third, and I'll hit this point quickly, with respect to the proposals to enhance transparency. This seems to be an area where there is clearly room for Congress to act. My own view is that the seemingly ad hoc nature of the recent government declassification releases is not actually helping as much as they might think. If declassification is the new norm, then there needs to be a more regularized and consistent method of releasing information. This might include amending the reporting provisions in FISA to provide additional public information, whether it's statistics, declassified legal opinions, summaries of implementation actions, or reports on compliance matters, semi-annually, quarterly, or at some other appropriate regular interval. In my view, this might cut back on each release being an event unto itself. Thank you very much for inviting me here today to share my views, and I look forward to your questions.
Senator Whitehouse, Senator Blumenthal said I could go ahead.
And I think you should.
Thank you. Thank you. You're in the majority, don't forget. Professor Donohue, I understand that you've concluded that the bulk collection of phone records under 215 is illegal. I call to your attention that President Obama is a former constitutional law professor, editor of the Harvard Law Review, and you probably know that he has concluded that the program is legal both under statute and as a matter of constitutional law. Is it your view then that President Obama is wrong?
Yes.
Okay. Further question, this time of Professor Felten. You testified that telephone call metadata can reveal an incredible amount of information about a caller when aggregated with other data and analyzed. For example, you mentioned that metadata can reveal sensitive information about the caller's relationship, lifestyle, and activities, but under the FISA court order, bulk telephone metadata collected under Section 215 can only be assessed and searched by the government when it has reasonable and articulable suspicion that the phone number is connected to terrorism. Question, does your testimony underscore what a valuable, doesn't your testimony underscore what a valuable tool the collection of metadata under Section 215 is to keep the country safe? Aren't the relationships and the activities of suspected terrorists precisely the kind of information that the government should be trying to learn about them as rapidly as possible?
I certainly agree, Senator, that it's important for the intelligence agencies to have the ability to get this information about terrorists and their associates. And this, I think, goes to the issue of focus that I discussed in my testimony, where when focused on terrorists and their associates, certainly I think few Americans, if any, would object to this sort of program. But when it's unfocused across the whole population, it does raise the same kinds of privacy and civil liberties issues that arise with content. And therefore, I think it makes sense to think about how best to balance those issues in order to make sure that that the collection and analysis of that data is limited, is available where necessary, but is also not without bound.
Thank you. And I'll go to Professor Cordero. I'd like to describe a few aspects of how government attorneys practice before FISA. For example, do Justice Department lawyers who appear before FISA courts have an obligation to present both sides of an argument, including law or facts that run counter to the government's position? And would you say that their presentation of opposing views is as vigorous as would be accomplished by an independent advocate?
Thank you for the question. With respect to the practice before the court, the practice is ex parte in camera. And what that means for the attorneys for the Justice Department who do that practice is that they have a heightened obligation in the FISA court practice, in addition with respect to their ethical obligations as members of the bar. Whenever attorneys practice ex parte in camera, they have a heightened obligation to bring both the facts that are supportive of their case, but also derogatory information or contrary information that might be relevant to the court's judgment. And so certainly my experience at the Department of Justice was that that was how we conducted our business. In addition, the court has legal advisors who conduct independent review, and then there are the members of the court themselves who are independent district court judges. I would also commend to you Judge Walton's letter to this committee in July, where he explained the process between which the government works with the court and when the court asks questions and how the government responds to those questions. And it's a very extensive and probing process.
Excuse me, Senator, may I add something to that particular response, please? Sure. Thank you very much. I just want to mention about the Foreign Intelligence Surveillance Court. They're not performing the function that they were originally envisioned to perform under FISA. They were supposed to narrowly grant orders. And what we're seeing is there are dozens of secret opinions, which we haven't seen. Some are, as of July, we found out there were hundreds of pages long that actually make rulings on very complex, difficult constitutional questions. So there's a special exception that the Foreign Intelligence Surveillance Court has carved out for foreign intelligence out of the Fourth Amendment. The Supreme Court has never recognized in the special needs doctrine a special exception for foreign intelligence. In order to adequately air these views, having opposing counsel, or what Senator Blumenthal has suggested, a constitutional advocate there, would help to do this. The recently released opinion that Judge Egan put out, it's only 3 double-spaced pages on the constitutional questions that are far more complex that are encapsulated in that opinion. So to really adequately air what the court has become, it really is important to have somebody there as a constitutional advocate. Thank you.
Could I ask one more question? This will be my last question for you, Professor Cordero. In your experience, how often does FISA court challenge proposed government applications by signaling that they may be insufficient? Describe the process by which government lawyers attempt to resolve possible insufficiencies for the court, including the role of legal staff. And does the high rate at which the court ultimately approves government applications reflect the process?
Thank you. So with respect, I don't have a numerical sort of number to give you with respect to how frequently the court questions the government presentations. In my experience, which ended in government in 2009, however, it was a very frequent occurrence that there would be exchanges and questions and answer periods between the government lawyers and the court on a very frequent basis, and it could happen at various levels. So, for example, if there was just a routine matter and there might need to be sort of small clarification questions, that might occur at the level between the court's legal advisors and staff attorneys. If there were more significant issues that might be at issue in a particular application or request, then that might involve sort of more senior levels of the Department of Justice engaging with either the legal advisors again or members of the court. And this process can continue. If there were extraordinarily significant issues raised in a particular request, that might raise the attention and sort of the involvement in the discussions with the court up to the level of the Assistant Attorney General for National Security or even the Attorney General. So it would be an exchange of questions and answers and an iterative process that, depending on the complexity of the matter or the judge's concerns, could either be resolved quickly or go on for some length of time. That being said, the overall numbers, as Judge Walton's letter had explained this summer in his letter to the chairman, the overall numbers of approved applications does not reflect that process at all, and it also doesn't reflect the scenarios in which the court might request changes be made to applications or proposed orders, whether the court modifies the proposed orders or requires that the government proceed in a different way. And it also doesn't indicate in that statistic whether or not there was a circumstance that the court indicated informally to the government that it might deny an application and the government then would withdraw that application.
Thank you, Mr. Chairman.
Thank you. Thank you, Senator Grassley. Let me begin by pursuing the the line of questioning that Senator Grassley just introduced about the constitutional advocate, which, as you know, I have proposed. And I know, Professor Cordero, you've outlined your concerns in depth, and I don't know whether some of those concerns would be addressed by the fact that the challenge or the questions to be raised would be done after, in time, the authorization of whatever surveillance might be indicated. Would that address some of your concerns? Because I think in your testimony you indicated that it would be a sea change for this kind of advocacy to be done before the authorization of whatever the surveillance might be.
Thank you. Yes, and in my written statement, I did have in mind sort of at the FISC level prior to collection, the idea of adding an adversarial process at that level. With respect to adding an advocate at an appellate level, it raises some different issues. Certainly, it would reduce the concerns about impeding operational speed and agility. So it certainly would, from my perspective, be better in that sense. But I guess the question that I would ask is sort of what problem is it trying to solve, and who the client would be of this constitutional advocate. Because I know from my experience, which again is a few years dated, but from my experience as the lawyers presenting these cases to the court in the ex parte in camera fashion, we operated in a culture that we were operating in the public interest, and that our client was the American public and the American citizen. And that was sort of the culture that permeated that office at the time, and I don't have any reason to suggest that that has changed since. In addition—
And I don't dispute that that culture existed then and existed now, and what we've seen, if you read Judge Walton's opinion about what resulted from perhaps an inadvertent failure to communicate, and you were here when General Alexander described the lack of communication between two areas of the intelligence community, that could happen again. The problem to be addressed is potentially that kind of mishap, which constituted a violation of law and was very significantly criticized by Judge Walton. In fact, he criticized the misrepresentation, and either the violation of law or misrepresentation certainly could have been addressed, not only at the appellate level, but at the FISA court level as well. So that is the kind of problem that that could be addressed. And I recognize, and I was a government lawyer myself, and represented the United States as well as the state of Connecticut, that government lawyers generally try to do the right thing, represent the American public, but their view may be affected by what they see as the public interest, which may be skewed to one side of an argument for granting a warrant or another, or approving metadata collection or not. And the adversarial process traditionally operates to bring out the truth. So that's my answer to your question: what's the problem, or what's the issue or need for some constitutional advocate? And very simply, who's the client? The Constitution and the constitutional rights of the American public.
So I guess sort of two thoughts on that. One would be, with respect, if part of the concern then is addressing the court's, what might be the court's desire, sort of as expressed by Judge Carr when he has testified before and in his op-ed, that the court would benefit from an additional view on constitutional issues. Then on that point, that's why I have suggested that it might be appropriate to consider whether or not the existing Civil Liberties Protection Officer, who was a position created by Congress to consider matters of civil liberties and privacy, that person might simply be more formally empowered to present an independent view to the court. And that way, that would be a person who is up to speed, knowledgeable, and aware of all the complexities of the issues, but might have a slightly different view that it could inform the court about versus that presented by the Justice Department on behalf of the intelligence community.
Thank you. My time has expired. I have additional questions, If there is no objection, I'm going to turn to my colleague, Senator Whitehouse, rather than keep him here, and then return to my questioning.
I think it's within the chairman's right to have as many rounds as he pleases, so have at it. But thank you for recognizing me. Let me start by saying to Ms. Cordero that I think your practical experience in this area gives, at least to me, your testimony additional weight, and I appreciate it. And I thought you made a very significant point when you talked about the need for more regularized and consistent methods of releasing information. I think that was the phrase that you used. We are still looking into it, but it appears to me that our intelligence community was caught flat-footed by the sudden, unexpected, unauthorized disclosure of classified information. And in the early days, it had all of the outward appearance of a mad and unprepared for scramble. An aircrew prepares for the eventuality of a sudden, unexpected decompression of the aircraft, for instance. And I do think it's important that our intelligence community consider what we now know to be the virtual inevitability of these types of releases taking place, and have a more robust, immediate response to that eventuality, but also bet on it happening in the future and be more candid with the American people in the run-up. Because I think a good deal of what has been disclosed could have been disclosed earlier, and I think the downside of classification in this area is very real. There's always an upside. It protects our sources, it protects our methods, it protects people who are helping us, it makes successful programs continue to be successful because people don't avoid them. If you disclosed who you were wiretapping, obviously your wiretap would fail, and we don't do it that way for very obvious reasons. So there's some real value to things being classified, but there are also all sorts of oversight and other issues that are raised, and I think you have a very balanced and sensible suggestion about trying to do that on a regular way, and I look forward to working with you to develop that further. Is it Professor Felten? Professor Felten, you said it was important that this information be available where necessary to our national security officials. Given the nature of the operation, that means it has to be somewhere. You have to be able to have the information. You don't get the luxury of being able to go back after the fact and figure out what you should have collected. So by your hypothesis that it needs to be available where necessary, I take the implication that collecting the whole haystack is necessary, because otherwise it's not available where necessary. You can't know that in advance. The second part of your point was that it must be available where necessary, but it has to be limited to help protect the privacy interests that are here at stake. Now, the way we've customarily done that over the years has been through mitigation techniques that go originally all the way back to wiretaps, where the FBI agent listening in on the wiretap in the headphones would listen to the conversation, and if it looked like somebody was ordering pork chops from the butcher or talking to their mom, you'd flip off the conversation for a while, and then you'd flip it back on to see if it was still unrelated to the criminal investigation, and you flip it back off. And obviously it's gotten a lot more sophisticated since then in this new environment. But do you concede that the whole haystack method, protected by adequate mitigation, is actually necessary to accomplish the result that you have indicated is ideal, which is that the data to protect our country should be available where necessary?
I don't think it's necessary to collect all of the data immediately. My view is that the policy with respect to metadata, the policy trade-offs with respect to metadata, are becoming more similar to those with respect to content. And the example that you gave of minimization on a traditional wiretap, even while the wiretap went on, is a non-collection of data because there is not because there is not enough reason to believe that it's relevant to the purpose. And this is a balance that has been going on with content for a long time.
The difference, of course, is that that's one thread of information, and the necessary protection purpose is accomplished by staying in real time, by listening to that conversation as it develops. When you're trying to connect a network of contacts that a terrorist overseas might have, it's too late in the game to build that network if you don't have the information necessary to do that. Otherwise, you're working, I mean, you may eventually be able to do it, but you risk a timing problem with, by the time you have developed that network, you have missed important players in it, and the event that you're trying to prevent has taken place already. And it's the preparedness, I think, that is an important part of this. So I guess I would put myself on record as disputing that the haystack plus mitigation modality isn't adequate. And let me ask all of you another question. We've talked a little bit about the, it has been long established that the kind of metadata that is collected through these programs is not protected by the warrant requirement. Everybody who's been in law enforcement here, Chairman Leahy, Chairman Blumenthal, myself, Senator Klobuchar, former U.S. Attorney Jeff Sessions, we've all gotten access to this data without a warrant, and it actually is achieved pretty readily. And in fact, in the early days, it was done almost informally with the phone company, and now it's been regularized more. So there is an unquestionably vast amount of both legal and practical precedent for that proposition. At the same time, mitigation has taken place for a very, very long time and is also equally well established both as a legal protection and as a practical means of doing this. So there you've got long established legal and practical precedent, and I think it's reasonable to draw conclusions from that looking forward. Now, to my question, there's another long established precedent, which is that if you're the police chief and you want to put a tail on somebody you suspect, you don't need a warrant for that either. You can take a police officer or a plainclothes officer and say, look, we need to know where this guy's going. You tail him and let's find that out. And that's been true for as long as there's been law enforcement. So again, another long established precedent. Then along comes United States versus Jones. And in United States versus Jones, the police decided that instead of just tailing Antoine Jones, they would put a beacon on his car and they would track that beacon, which would obviously save law enforcement resources, take advantage of new technologies, be the smart thing to do, et cetera, et cetera, et cetera. The Supreme Court in that case said that that was a search and that that required a warrant, even though following him around would not have required a warrant. And while the constitutional basis for that decision I don't think is fully settled yet, there was a bare majority that said it's because of the physical trespass by putting the beacon on the car, but there was an other majority that said, no, actually, you've got to look at, they were unfortunately in the form of a concurring opinion and another concurring opinion, so they didn't form five. But if you read Justice Sotomayor's concurring opinion and the concurring opinion of four, they're all saying, look, just under the expectation of privacy test, this is a search also. So I deduce from that that there is a point, in fact, where new technology and scale change the underlying nature of what had forever been a non-warrant requiring search. And so I think it's an actually very live constitutional question how United States versus Jones should apply to these programs. I've yet to see an opinion of the FISA court that addresses that. The Egan opinion came out very recently and did not address it came out since the Jones decision and did not address it. So I'm interested in each of your views as to how you would expect the FISA court to rule when a case came up that obliged it to look at the application of United States versus Jones, the Beacon decision. And let me start with Professor Cordero.
Okay, thank you, Senator. Certainly the Jones case is on the minds of everybody who considers these issues. With respect to—
Except Judge Egan, evidently.
Well, with respect, though, to Judge Egan's opinion, so what she said is, and I'll quote, she said that the production order under the 215 is, quote, squarely controlled by the Supreme Court decision in Smith v. Maryland, and the Smith decision and its progeny have governed Fourth Amendment jurisprudence with regard to telephony communications metadata for more than 30 years. There have been 14 judges of the court who have approved the 215 program since 2006 34 times. The Jones case came after 2006, but there still have been at least some of those judges who have continued to approve the 215 case subsequent to the Jones case. And so that might be perhaps one suggestion that that the court is still satisfied. Judge Egan also said that the fact that the data was not collected in bulk in the Smith case, or if you take the inverse of that, that it currently is conducted in bulk, she said that that would not change her analysis. So that being said, as I mentioned in my written statement, this is certainly an area where the law may change in the future. In the Jones case, the majority that held, as you mentioned, the majority that held that the GPS surveillance was a search held it on the trespass grounds, not on the grounds that actually following the person around through the GPS surveillance was the search. It was the second sort of concurring majority part that said that had they decided the grounds, had they decided the decision, they would have held on that grounds. But as you note earlier in your remarks, that actually turns what are sort of traditional investigative techniques of physical surveillance on its head from formerly being one of the most least intrusive techniques to now all of a sudden flipping it up to a warrant requirement.
I think rather than ask the other two to respond, I have now gone so far over my time that it is really impolite to the chairman.
You can go further.
Well, then we'll finish with their answers and I'll yield. But I appreciate very much the chairman's patience with this.
Thanks. Well, I don't have the legal expertise to predict how a court would interpret Jones. But with respect to your discussion of law enforcement and police access to metadata, certainly this has been going on for a long time, and appropriately so. The modality there has not been one of transferring all data to law enforcement and then having them pull out the pieces they want later. The law enforcement and prosecutors have been able to go to the phone company and get the records they need when they need them. Certainly, I would agree that technology provides new ways of managing this process, and one of those ways is to allow an intelligence agency to get the data that they need in a targeted and focused way in real time without needing to transfer all of it from the beginning.
Professor Donohue.
There we go. Thank you for your question. I'd like to address just briefly the minimization technique point that you raised and then move to the question that you posed. On the mitigation techniques, minimization was only one of many protections that was built into the statute. FISA also had prior targeting before you could place intercepts. You had probable cause that an individual was a foreign power or an agent of a foreign power. You had the Foreign Intelligence Surveillance Court, and you had a higher standard for U.S. persons. All of that has been swept aside for the 215 metadata program. Now, there's a general order. The NSA determines RAS, whether there's reasonable articulable suspicion. There's not a different standard for U.S. persons.
Swept aside for the metadata program. The metadata program faces the reality that unless you are gathering the information, you don't have a haystack to search in. But it doesn't mean that a search actually ever gets done of the haystack, and the steps required to search the haystack are far more rigorous than all the ones that you just mentioned.
So the problem is that in building the haystack, all of the protections have been thrown out. And with the type of information that you can get from this telephony metadata.
And that's kind of the question, isn't it? Is the building of the haystack the search or not? Even if nobody knows what's in it, even if nobody knows it, is there a privacy interest that is lost when nobody knows that you made those calls, but there's a haystack out there, and under the right circumstances, somebody could find out?
And there are two responses to that.
That's an interesting, that's kind of the crux of the question we've got.
There are two responses to that. One is the Foreign Intelligence Surveillance Act is about the acquisition of information, which is when that information is acquired. And second, I would go back to the general warrant. The purpose of the Fourth Amendment was to prevent general warrants, which was to search for information and to conduct searches indefinitely without any particularized showing. And there is a constitutional violation that goes on in that case.
Although there are lots of things that people do in law enforcement and have since the dawn of time that they don't even need a general warrant for because there is no warrant requirement. And so you can't use the warrant requirement as a criticism of the way in which that's been done. It's never been within it. So things that weren't subject to a warrant requirement don't require a general. The general warrant problem I don't see as being pertinent here.
No, this goes to the reasonableness or unreasonableness of the search itself. That was the point of the founders. That was why Jefferson included this. This is why Madison was talking about this. This is why it was in the Virginia Declaration of Rights. This is why New Hampshire, Massachusetts. It was the actual reasonableness
of what's a search.
Of what is a search? Well, the reasonableness or the unreasonableness.
Does human knowledge define the search, or does its availability in the haystack define the search? And that's, I think, a really interesting and important question that we need to address. But I don't think you can jump across back and forth between those two definitions and still have a logical and practical discussion.
Okay, let me address your second point as well, which is this broader question, if you can use these powers in law enforcement. And there are two parts to this. One is the pen register abilities that law enforcement has, and second is the subpoena powers. And just on the subpoena power point, you can't go on fishing expeditions. You can't, convene a grand jury in Bethesda and just see what's happening in town and start mining it for information. You can't use a subpoena as a generalized information. It has to be material and specific to a particular suspected crime or individual or series of activities. This is not what we're discussing. This is not what could be otherwise obtained by a subpoena ducis tecum, which the statute requires, and which the Fisk judge, Judge Walton, said there is no other legal way you could get this information. So it is very different from the kind of subpoena power that somebody would have in law enforcement. On the pen register side, I think you're exactly right to highlight what's going on with Jones and the extent to which metadata and the types of things that Professor Felten is discussing have changed the incursions into privacy that are possible. In the case of Smith versus Maryland, Michael Lee Smith had robbed, harassed, threatened, made obscene phone calls, drove in front of her house, tried to intimidate her. And on that basis, they got one pen register that within the 24-hour period, he called her again. They went into his house, they got a general, or not a general, they got a specific warrant, they went into his house, they found the phone book turned down to her name. That is a completely different situation.
But that wasn't the holding of the Supreme Court in that case. If we're going to talk about the case, the holding of the Supreme Court in that case wasn't because he behaved in those awful ways, you're entitled to get this. The holding was, this isn't Fourth Amendment warrant requirement protected in the first instance. And it didn't matter whether he had been awful and engaged in all sorts of abusive and ghastly conduct or not. There is a Constitution line that it drew, and the holding was that that kind of pen register information simply doesn't require a warrant, period.
And I would respond to that. You're absolutely right. In that situation, it did not require a warrant. What we're talking about is the wholesale collection.
Nor has in any situation since, right?
Well,
it wasn't.
Certainly, the shadow majority in Jones found exception to that. Justice Alito's opinion, joined by three other justices.
Now we're back to my question about the shadow majority in Jones, and I will accept that. But I don't think it's fair to say that Smith was a case that's defined by its facts in any way. It's been one of the cases that has had the broadest practical and judicial acceptance in real law enforcement life of anything. It's gone on for
And yet Justice Sotomayor in Jones goes on to say that she would not extend to third-party data the same protections that they would otherwise not deserve under the Fourth Amendment, precisely because of technology. We've seen this also in the circuits at an appellate level. We've seen a number of judges express the same.
To summarize, because I'm now going way too far, to summarize, you do think that it would be incumbent upon the FISA court to consider the Jones decision at a minimum, and in your view, in considering it, they would likely further restrict the capabilities of this program?
Not only should they consider it, but this also goes back to Senator Blumenthal's point of the necessity of having a constitutional advocate there who can bring up Jones and these other cases. It's, as you note, it's nowhere in Egan's opinion. And to have somebody there who can bring this up so that the court does have to wrestle with this and address this directly.
Thank you, Chairman. You've been immensely patient.
Thank you. I want to thank Senator Whitehouse for raising Jones and this issue of technology having to be considered by the FISA court, because it does revive the point that I made in the previous panel that a lot of the constitutional jurisprudence seems to depend on the Smith v. Maryland case, and the technology there was really very primitive compared to what we have now. And if at least a number of you feel that Jones may be relevant and should be considered by the FISA court, let me go back to Professor Cordero. Wouldn't it be useful to have an advocate to, in effect, present in an adversarial way the implications of the Jones case in testing surveillance conducted under this very, very different, profoundly different technology?
Well, as this committee is aware, and as the Intelligence Committee is also, this committee is in a position to receive information that's not available to the public that involves pleadings or opinions that the court has made beyond that which has been identified. So I don't know whether or not Jones has ever been considered by the FISA court in any of its decisions. It may be that it has, and it may be that that's information that would be available to the committee or the intelligence committees. But that being said, the court has a rule that when there are new or novel issues of technology or law that are being presented to the court, that it requires a memorandum of law from the government. And so the government needs to explain and bring to the court's attention, court, this is something that you haven't seen before, and here's our memorandum of law explaining sort of the parameters of that. And whether that would involve the Jones case or some other relevant case law, certainly it would be the practice of the department as a general matter to inform the court and bring to the court's attention relevant case law. Again, I can't speak to whether or not this specific case has been an issue that has been arisen in memorandum of law that the department has provided, but I certainly wouldn't be surprised.
You can't speak to it. Are you saying that, to your knowledge, Jones hasn't been presented? Because I'm not aware of Jones having been part of any litigation.
I simply don't know, sir, because I left government at the end of 2009.
Okay.
So I simply don't have that information. Perhaps the committees do, or perhaps the other committees do.
But so far as you know, and you cited a certain number of judges and a certain number of opinions, 14 judges and 34, did you say? Instances,
right, where the 215 program was affirmed by the court. But speaking
none to your knowledge has considered Jones.
Well, when I'm saying they have, whether or not they've considered Jones, I'm speaking a little bit more generally. So not just with respect to 215. As a general matter, if the government were presenting novel issues of technology or law, they would brief the court on those issues. And I would expect that they would bring important cases to the court's attention.
And I understand your point that the government has, as you've referred to it, a heightened obligation because there is no one on the other side. But there is an institutional interest and maybe even a national security interest in the government not raising for the court, by the way, Judge, you know, here are the ways that Jones could really challenge this whole construct of jurisprudence on which the warrant procedure rests. And here are the, in other words, it may not be directly raised by a specific request of the court, and it would take a great deal of heightened scrutiny or heightened obligation for counsel to, on its own initiative, raise a challenge of that kind. So we both know that courts are always make better decisions if they hear both sides of the argument through an adversarial process. It is a theme that runs through our court system. It's one of the underpinnings of our jurisprudential system. And you have indicated just now that perhaps the office of the Civil Liberties Protection Officer could provide some kind of substitute, but of course that officer now, under statute, reports to the Director of National Intelligence. There's no way that that officer could present an objective or independent view, either in litigation or even in advising the court. So I come back to the question, doesn't the question that Senator Whitehouse has been raising about the implications of Jones raise again, shouldn't the court, FISA court, have been hearing exactly these kinds of questions?
Well, I guess, Senator, what I'm suggesting is that I think there's a reasonable possibility that the government, in fact, would brief the court on a decision of such import in its capacity of providing a memorandum of law regarding the issues that it would provide in its ex parte in-camera process. In addition, with respect to the special advocate, I think there also could be some consideration to the relationship that exists currently between the government and the FISA court. And I think that relationship and sort of the exchange of information and the process that goes back and forth is explained in Judge Walton's letter. In considering the proposals for the advocate, I would hope that the committee would sort of take into advisement whether or not adding an adversarial process might actually disrupt in some way that relationship of trust and work together that the department and the court have developed over a course of decades.
Sorry, Senator, may I add something to that?
Yes, I was actually going to ask both Professor Donohue and Professor Felten to comment.
Great. So I want to recognize at the outset, in 2009, it was the Department of Justice that actually recognized that there were noncompliance incidents going on, and they were the ones that reported it to the Foreign Intelligence Surveillance Court, that for the first 3 years the program operated, that actually of 18,000 inquiries per day as of January, only 1,800 or so had reasonable articulable suspicion. It was DOJ that was performing its due diligence and reported that to the court. With that said, as Justice Jackson reminded us in Irvine versus California, the executive is hardly a disinterested neutral observer when its own interests are on the line. We read in Federalist 47 and 48, Federalist 51, when Madison says the ambition of the man must be aligned with the ambition of the office if government is to govern man. We must find a way to get it to control itself, that these checks and balances are very important. And as you note, within our judicial system, we have adversarial processes to ensure that individual interests don't taint the outcome of cases. And so I think it's terribly important to have somebody there to represent constitutional concerns that doesn't have an interest that might otherwise be swayed, and that provides another voice to the court, especially if they're going to be considering such weighty constitutional questions and then issuing opinions secretly, hundreds of pages long, that carve out exceptions to the Fourth Amendment. You absolutely have to have an adversarial process involved in that.
Thank you. Professor Felten.
Whether it's through an adversarial process or through the government presenting the full scope of information to the court, when it comes to issues of complex technology, it's important that the court has access to the kind of expertise that it needs to make a well-informed decision. And perhaps that takes the form of the court being able to use a court-appointed expert or a special master, perhaps, if there is an adversarial process. Whoever it is that is arguing on behalf of civil liberties or the public also has access to the expertise that they need to do that well.
Thank you. Senator Whitehouse, did you have other questions?
Mr. Chairman, I just wanted to observe that actually in our own procedures here, we do our very best to try to create that adversarial exchange of views. Clearly, Professor Cordero and Professor Donohue have very different views about what should be done here. Each has acquitted themselves, I think, with very great ability in this particular forum, and it is a virtual constant that in our hearings we have witnesses from different points of view so that we can hear those. In my years on the Intelligence Committee, I really felt that we were, a difficulty was created for the committee by the fact that in deeply classified programs there was no way that you could bring a different view in, and so in the same way that the government has a heightened standard, I think we all felt very keenly the heightened standard of inquiry necessary because there was not public inquiry and there was not exchange of views. But and that to me is, we vote with our feet sometimes. And in Congress, I think we have voted with our feet in favor of as close to an adversarial type method as we can in the way we conduct our hearings in the ordinary course. And so I'm not sure that the mechanism of an independent body that is all on its own is exactly the right one. But I am firmly in your camp that improving that ability for the FISA court to have a broader range of views presented to it and to build in the adversary process is an important step in the right direction.
Thank you. I appreciate those comments and your questions earlier. And I want to say that this is a very difficult and challenging issue or set of issues, and I really appreciate the testimony that has been given by this panel. I have been enlightened by the somewhat adversarial exchanges here with some of you, and I think that the subject bears a lot more thought and consideration. I'd invite each of you to submit additional comments and hope that I can consult with you because you bring a set of experiences as well as expertise that I think will be very valuable as we move forward, and particularly to my colleagues. I will encourage them as well to consider all of your views. So thank you for being here. Thank you for your excellent testimony. This hearing is adjourned. We'll keep the record open for 10 days, and please submit additional comments if you have any. Thank you very much.